Hi, Nelson. And hi, everyone on YouTube. I am a now unmuted Eric Citron. I'm a contributor to Blog and an attorney at Goldstein and Russell. Nelson, if you recall. Nelson, why don't you introduce yourself?
Sure. I'm Nelson Tebbe. I teach at Cornell Law School, where I run courses on constitutional law, freedom of speech, and freedom of religion.
And we are debriefing after the Little Sisters argument by telephone this week. We did a preview last week. The court heard argument by phone earlier in the week, and now we are going to talk about what we heard. Nelson, I'm curious what you think you heard on the phone. I was live blogging it. I said I thought it unlikely that the Third Circuit's decision was going to be upheld. Is that your bottom line too? And what do you think the court might do?
Yeah, as we at least I predicted last week, it seems like there are clearly 5 votes to uphold to overturn the Third Circuit's decision and uphold the regulations, at least the religious regulation, the religious exemption. And the only question is, what the vote split will look like. We might not see just 2 opinions. It seems like there may well be at least a 3-way split. That was my reading anyway. Did you see that as well?
Well, it's hard to say what kind of split will result because I'm not even sure that the justices know exactly what the case is about. There seemed to be a lot of frustration that the government and the Little Sisters or religious objectors generally hadn't done what the Supreme Court thought was possible last time and worked out some kind of accommodation far short of what the Trump administration has now provided, which is one that could harm employees. Justice Ginsburg was really focused on the fact that this seemed to harm employees, but without really framing it in the terms of what was being litigated in the case. It certainly seems like there are some folks eager to uphold the government's new accommodation, like Alito and maybe Gorsuch in that camp, maybe Kavanaugh in that camp, and some folks eager to overturn it. That's maybe Ginsburg and Sotomayor, and then a bunch of folks not exactly clear on what they want to do, but maybe focused on some of the narrower questions in the case around the APA. It seems possible that the court will sort of vacate the Third Circuit's decision, but leave open the possibility of future APA-based challenges to ideally, I think, on behalf of individual, actually injured folks who claim that they've been denied something they should have gotten as a result of their employer's exemption. But I doubt this case is going to result in a sort of broad symbolic holding that either side is looking for, if that makes sense. I want to remind folks that we have a Q&A that you can join, and you can submit your questions about the case. We really like it when you do that. It makes this conversation a little bit more lively. Did you hear anything that surprised you, Nelson, during the argument?
Well, the attention to the arbitrary and capricious standard as the substantive APA kind of issue, which was really absent in the lower courts, was interesting, right? I mean, it seemed like some of the justices who were especially focused on whether there was a kind of compromise solution seemed also drawn to the idea that they could rule that the government had authority to promulgate this rule under the ACA itself. So even maybe independent of the Religious Freedom Restoration Act, and that would cover the Little Sisters themselves. So the rule would be upheld as to them, but then they could write an opinion suggesting or inviting other types of employees, say, of for-profit companies or employees whose employers had invoked the moral exemption, to bring as applied substantive APA challenges under the arbitrary and capricious standard. That was something I hadn't seen in the lower court litigation. The lawyer for Pennsylvania said that an arbitrary and capricious substantive APA claim was in the complaint. So it's been part of the litigation from the beginning, but that the Third Circuit ruled in their favor on other grounds. And so it just never came up. I was a little surprised by that. Were you? Oh, you're muted.
Yes, I was surprised by that. And related to that, I think I was most surprised by the earnestness with which the Chief Justice sounded like he was questioning what the government had done and what it was arguing and what the Little Sisters wanted. He seems to have been coming at the case from the perspective of thinking that it had been more or less solved after Zubik, expressing, I think, real frustration that they were still doing this, and some dismay that the case had turned into an effort to secure what he said, at least, bothered him as an overly broad take on what kinds of exemptions RFRA might authorize from otherwise generally applicable laws. The case was framed almost instantly by the Chief Justice's first question as, isn't your RFRA argument way broader than it should be? And I think that kind of drove future questioning towards the APA as the compromise position. And since the Chief is really right in the middle of the court right now, especially on these religious freedom issues, I think it was both interesting to see how dismayed he sounded with the current posture of the case, and what positions he was floating as plausible resolutions.
That was interesting. He's not the only one. He's not alone there. Justice Breyer is also clearly looking for a compromise solution that could satisfy both sides, and he expressed almost identical frustration. And some other justices jumped on board. Even Justice Gorsuch, sort of looking to an APA kind of solution. But can we talk that through for a minute? Let's try to understand in a way that's kind of fair to both sides what the claims are exactly, and then whether they could be reconciled in this kind of compromise way. Obviously the parties didn't think so after Zubik, and I wonder whether anything's changed there. So first, what exactly is the complicity nature, the nature of the complicity claim on behalf that Little Sisters is making? Because it's especially kind of mysterious with respect to them, because they have a church plan, as we talked about last time. So whatever happens, it doesn't look like their employees are going to get covered as part of that plan. And what's more, their CPA, the Christian Brothers, has said that it will refuse any incentives from the government to provide that coverage on its own. So that contributes to a standing question, but also on the merits, one wonders what exactly the complicity claim is being made by Little Sisters. And as best I can tell, their claim is this: if we are required to notify the government to object, that is, then the government will use that information to try to incentivize our third-party administrator, the Christian Brothers, is the name of the organization here. And even though the Christian Brothers will decline that incentive, the fact that the government is using our notification to contact our TPA and offer them incentive is enough to establish complicity. I think that's the claim on the Little Sisters side. And on the government side, the argument is it's really important for the health of women employees that coverage be available to them in a way that minimizes their search costs. and the kind of logistical costs that they have to incur to achieve or receive that coverage. So if it comes from the same insurer or a third-party administrator that they're getting ordinary medical coverage from, then that lowers the costs on employees to find cost-free contraceptive coverage, the search costs, administrative costs. And that's really important. Like we've found, this is the government talking, we found through our own fact-finding at the agency level, but also through fact-finding by district courts and the Zubik litigation and this litigation, that if those costs are high, the search costs or administrative costs on employees, then some employees will lose contraceptive coverage, and that will impose harm on them that is irreparable.
Yeah.
Right? So that's the position of the two sides. Now, how is a compromise available? How would that work?
Well, I'm not sure, in part because, I've not been privy to efforts to make the compromise or make it work, and no one actually has been. But it seemed, Justice Kagan really did pose directly to the Little Sisters lawyer, the question, do you object to objecting?
Right.
Or imagine you objected to objecting. And Paul Clement was pretty clear that they don't object to objecting. They object to some aspect of how the government processes that objection. And it could be that the government has no good options for how to provide or direct employees to coverage after an objection. But the belief, I think, is that there is some more direct way for the government to provide the benefit or make sure that the benefit gets provided. I think that's a pretty technical question of what the ACA permits in terms of design for this kind of thing. But, if the government was going to do something that doesn't seem authorized by the ACA in order to try to accommodate this kind of one-off moral or religious objection, I'm not sure who would complain and whether you would see successful challenges or not. So my guess is that there is some compromise out there that is workable for both sides. But there is some obstinacy, I think, on both sides in terms of willingness to find something that does work.
Yeah, I mean, with respect to the Little Sisters, they've already identified themselves as wanting an exemption, right, by litigating, right? So, like, the government knows that they exist, and the government knows who their TPA is and so forth. But I think the concern with respect to other religious nonprofits or other entities that are covered by these rules is that it'll be hard for the government to know that they have stopped providing coverage to their employees and to identify who their third-party administrators are. It's sort of hard to understand how the government will be able to offer these incentives to TPAs unless the employers give some kind of notice. Maybe you could put the burden on the employees to provide that notice, but again, the more barriers you put in the way of employees receiving coverage, the more harm will result. I guess another possibility is that the government could provide kind of a freestanding program, right, that would just provide cost-free contraceptive coverage to everybody under Title 10 or some other program. But as you and I discussed last time, the political barriers to doing that are really very serious.
Yeah.
So it doesn't seem practical. I can't imagine Congress kind of enacting that kind of program, at least as Congress is currently constituted. So I don't think that's a sort of credible alternative. But I'm not sure how the compromise would work.
Yeah. I guess I'm not sure either. And then there's the question, like, does the compromise does it take the form of like a government, compromises are easy to work out in ordinary bilateral litigation among private parties, but they're harder when, it's one party on the private side that has particular concerns, and it's the government trying to enact a generalizable program on the other. It might be that there aren't actually a lot of groups that have it's not objecting to objecting, but it's close to objecting bone to pick that the Little Sisters do. And it may not be necessary to have much in the way of accommodation available for that particular problem. The Trump administration chose to do something much broader. And, you know, I was having a back and forth with Abby during the live blog about how, you know, notwithstanding certain justices are very frustrated that they didn't get the compromise that Zubik was pointing towards. That compromise is really off the table once the administration itself has chosen to do something broader than the Little Sisters were even asking for. Because now the Little Sisters don't need a compromise. They've got more than what they wanted, they say. And the folks on the other side could try to work out a compromise with the government, but they're new to the case. And they are, and the nature of their objection still has to be refined. And is not particularly refined because it's not being presented by actual employees with a, you know, who have a particular set of demands or ideas about how they're injured and what would make it better.
Yeah, I mean, it's tempting, I think, for the justices to say, well, we can make this go away as to Little Sisters. And, you know, Pennsylvania's lawyer said, you know, we've never sued Little Sisters. Like, we have no problem with what's going on with respect to them. We sued the government and they intervened. But that raises a problem, right? Because even if this case goes away with respect to Little Sisters, that's not the core of the litigation. And in a way, like the Little Sisters issue is important because there may be other entities like them out there, but it's not the be all and end all of this litigation by any means, right?
Yeah, well, I mean, I think it's only because of Zubik and the previous litigation that we're still even talking about the Little Sisters, because their objection is not at the outer reaches of what the Trump administration's exemption accommodates and allows by way of injury to employees who want coverage. You know, they have said they have no objection to their employees getting coverage at the end of the day. The Trump administration has allowed a situation where these employees will not get coverage at the end of the day. That's probably what the litigation should be about, but it doesn't present that way because it's confused. We did get a question from the live audience asking if we can explain the difference between the religious exemption and the moral exemption. I think, you know, the in terms of, actually, Nelson, is there a difference between the religious objection and the moral objection, other than what the objection amounts, the reason for the person's objection?
Well, the reasons, you know, kind of matter. So if someone has a non-religious moral objection to the contraception coverage, then they would bring it under the moral rule. But there are some important legal differences. I mean, one is that the moral rule or the moral exemption cannot be justified by RFRA, right? So it has to have some other legal basis, and that would have to be the ACA itself, right? The authority of the agency to promulgate that rule would have to be in the ACA itself. And at least the attorney for Pennsylvania yesterday or on Wednesday was very clear that he thought there was no such authority, or even if there was, that the rule would be arbitrary and capricious. There's just no reason to extend it that far. I think another big difference just practically is that the number of women who would be affected is much smaller. And the agencies found that between, I think, 70,000 and 126,000 employees would lose coverage as a consequence of the religious exemption, but for the moral exemption, it was like 8,000. It's not unclear to me why the Trump administration wrote that rule. We talked about this a little bit last time. I think they had in mind some entities that have become salient recently, like March for Life, which is a non-religious pro-life organization that's been prominent in litigation. So it probably because of cases like that, but the presence of that rule in the litigation is interesting. It hasn't been the focus of argument on either side, but I think we'll want to watch what the justices do with that rule and how it differs from what they do with respect to the religious rule.
Yeah, I think I basically agree with that view, that there isn't a big difference in terms of the effect of whether the objection of the rule in terms of whether the objection is moral or religious, but it certainly does affect the legal issue by way of RFRA. I think it's interesting, the resolution we've been talking about, it seems like the compromise position, actually by ignoring RFRA does mean that it, in a way, blesses the agency's much broader moral objection exemption. But it only would do so sort of temporarily or en passant until there was some direct challenge to the moral objection, ideally from someone who had been deprived of coverage by their employer's moral objection, which I'm not sure would ever materialize.
I just want to make an additional point about this compromise path. I still don't really see where it would wind up. I don't really understand what the compromise is or what it would be. But even if the court says, look, we're just going to say that these exemptions are authorized under the ACA, right? And then the only questions are that are posed by the APA. So RFRA is kind of out of it. Then we just ask substantively whether any exemptions are arbitrary and capricious, and then procedurally whether they follow the right kinds of notice and comment procedures. I think some justices are going to go that way. And the only thing I would add, although I don't have a huge problem with that approach, except I do think it's important then to remember that the Establishment Clause imposes an independent bar on religious accommodations that impose costs on other private citizens. So the Establishment Clause claim becomes really important if RFRA drops out of the litigation, because then the concern for third parties doesn't have a hook in the statute, but instead has to rely on the constitutional claim.
Yeah, I want to respond to that, and I also want to note one of the questions that we've gotten. Someone asked, their understanding was, hadn't the APA issue been addressed in the Third Circuit by the Third Circuit addressing the question whether the ACA authorizes this kind of exemption? And I think what Justice Breyer was suggesting, and I think what some of the other justices were hooking on to is, well, there's two questions that are typically posed under administrative law, two kinds of questions you could pose under administrative law. One is whether Congress's statute itself prohibits something that the agency has chosen to do. That question is usually resolved by Chevron deference and other doctrines involving statutory construction. And then there is the separate question of whether what the agency has chosen to do is just in itself arbitrary and capricious, because it doesn't make any sense, it's internally inconsistent, it's pointless, it hurts way more people than it helps, or the like. Or procedurally so, they didn't respond to a meaningful objection or something like that. And I think what the justices were suggesting, what I've been calling the compromise position, not as a compromise between the Little Sisters and the government, but as a compromise among the justices, is to say, look, we think this is authorized. We don't think the ACA itself prohibits the making of exemptions from this rule. But there is the question whether an exemption of this breadth is actually justified. And that should be resolved in ordinary APA, arbitrary and capricious litigation. And my question for you, Nelson, based on your last point is, you said harms to third parties can become Establishment Clause violations. But is that true if it's just a moral objection, if it's not actually establishing any particular religious objection as important? It just says we're going to allow an exemption for people who don't want to comply for moral reasons. We're not valuing their religious objections over their non-religious objections or anything like that.
Yeah, that's a good question. Look, as a matter of legal and constitutional theory, I actually do think it would extend that far to all conscience-based claims, and I think you can make an argument for that under existing law. But here, I would say, we're just like sort of talking about litigation in the Supreme Court and what's going to prevail. I would say, the place where the third-party harm concern applies most directly is where there's a religious exemption. But that's what we're talking about. So we're talking about the agencies crafting religious exemptions using the discretion that Congress gave them under the ACA and using the right kinds of APA procedures, right? Even if they do that in a way that's not arbitrary and capricious, if it imposes substantial costs on other private citizens who don't share the religious beliefs of the Little Sisters or Hobby Lobby or whatever, that's an Establishment Clause violation under the Supreme Court's precedents. And that issue was raised by Justice Ginsburg and Justice Sotomayor, and to some degree was addressed by the lawyers. But I would just insist that that's an important restriction on the government's ability to act here, even if the Religious Freedom Restoration Act drops out of the picture.
Yeah, I think that is the best way of understanding what Justice Ginsburg and Justice Sotomayor were talking about, although they didn't talk about it as an Establishment Clause violation when they were asking the question.
No, because Justice Ginsburg wrote a unanimous opinion in Cutter against Wilkinson, which was about Arlupa, which is a very similar statute, where she kind of incorporated the Establishment Clause concerns about harm to third parties into a RFRA analysis or a statutory compelling interest analysis, and said that harm to non-beneficiaries had to be taken into account when the statute was applied by the courts. As long as that's true, and again, there's unanimous opinion that drew on Establishment Clause cases, then you don't need freestanding Establishment Clause limitations. But
unless you don't think that this case is a RFRA case at all, right? Like the framing that Justice Breyer and the Chief seem to be pushing doesn't require answering any RFRA question.
No, but it's still a religious exemption. Still, the agency would say, like, we're going to give this exemption on the basis of religion. Even absent RFRA, that would still implicate the Establishment Clause. That's my point.
Yes, I agree with that. I think where the rubber meets the road is that if they do say, that this is authorized by the ACA, it may, in certain circumstances or in general, create other problems, and those are for other litigations, then those other litigations will probably involve, I think, both APA claims and freestanding Establishment Clause constitutional claims. And then the question will be how successful those challenges are.
Well, why wouldn't those concerns be raised in this litigation too? I mean, the Little Sisters hires employees on a non-discriminatory basis, meaning like they don't limit their hiring to members of their own faith. So it seems like harm to third parties is an issue in this litigation also.
Well, I think it may just be a question of what is this litigation. The justices, I think, are a little thrown by the fact that it's just a kind of challenge to the exemption that the Trump administration decided to make. Some applications of that exemption might be Establishment Clause violations, while some applications are not. There are no injured employees. We haven't been able, justices ask questions like, is there anyone that you've actually identified who wants the coverage and isn't getting it, who works for the Little Sisters or otherwise? So it may be that they try to carve out those problems by saying, we're not sure they're presented in this case or something like that.
Yeah, I thought those questions raised an implication that was just mistaken. Like it seemed when the justices said, and this is straight from the arguments by the government and by Paul Clement for the Little Sisters, when they say you haven't identified any individual employees who have lost coverage, the implication of that question is no employees have been harmed, but that is not true. It seems like the agencies have estimated, not based on nothing, based on their own analysis, that between 70,000 and 126,000 employees will lose coverage as a result of the religious rule alone. And neither the government nor Paul Clement for these Little Sisters challenged that number. In fact, Paul Clement, I think it was, said that it was correct. I think the reason we don't have individual employees who have been identified is because the states are bringing this claim. Right. And the states don't have to identify individuals under Massachusetts against EPA. They can just say, look, those numbers are big, and that means that some of those costs will have to be borne by the states, and that's sufficient for standing purposes.
Right. I think that's right. I think it just does make the litigation. it might recommend against Massachusetts against EPA and some of the liberties that are taken with standing analysis. The best function of standing analysis is actually to get cases into well-framed postures where you have somebody who says, this is what's hurting me about this government program and I need that injury redressed. Because when you talk about them in the abstract, you actually do have problems like the ones we're trying to talk through right now, figuring out what the case is about, what needs to change in order for parties who actually care to get relief. Too frequently, it's really obvious that somebody is injured, and the government, the court throws up other standing issues that prevent them from getting into court. This is a situation where the people who are making the arguments really don't have, they're not able to give a concrete sense of how many people are injured, what their injury is. We know 75 to 125,000 people are going to lose coverage under the rule, but it's fair to ask how many of those people expected their religious nonprofit employers to provide contraception coverage for them, or want that coverage in the first instance. Paul made the point. A lot of people who work for the Little Sisters don't expect them to provide this coverage, even though the Little Sisters hires on a non-discriminatory basis and has lots of non-Catholic employees.
That's totally right. Look, it would have been better if there were, individual employees who were involved in litigation from the beginning. And, colleagues of mine and I have been saying that from the start. Unfortunately, I just don't know why there aren't.
Yeah. Well, you floated last time.
If they were. However, notice that, you're right, we don't know exactly how many, but one point that came out in oral argument, which is powerful, I think, is that this new rule will cover Hobby Lobby.
Yeah.
There's no reason Hobby Lobby doesn't need to rely on the pre-existing accommodation anymore. They can just use this new rule. And we know Hobby Lobby has 13,000 employees, and we know that many of them don't share Hobby Lobby's beliefs. It's just not that kind of organization, right? So the impact on third parties who want this coverage and don't share the religious beliefs of their employers is going to be large.
We have a question from the audience about the Little Sisters standing in the case. That question was, that it didn't seem to them that apart from Justice Sotomayor, there were any questions about the Little Sisters standing. And Paul Clement didn't really argue about that. What do you make of that? And do you think the justices that this just dropped off their radar, or that this doesn't really matter? I mean, I think in one way, whether or not the Little Sisters have standing seems a little bit beside the point. They're there essentially to present argument. The dispute is ultimately between the states and the federal government. The judgment in the case is going to be about whether or not the federal government has to do something in light of the state's claims. So it may be that the justices just don't think it matters at the end of the day whether the Little Sisters have standing or not.
I think that's right. But, if you think about the purposes of standing doctrine as you articulated them just a minute ago, it matters that you have people in front of the court with real stakes in the case. And it doesn't seem like the Little Sisters do, not because their employees will receive coverage, because their employees won't receive coverage regardless of the outcome of this case,
right,
but because they have to object in a way that does trigger some action by the government, namely the effort to incentivize their TPA to, right? So that seems like enough injury for them to have standing. I don't know that it's really a standing issue, but the existence of injunctions elsewhere that protect Little Sisters nationwide is troubling, right? I guess the best I can do to say that the Little Sisters might still have standing is to say that the Third Circuit opinion actually undermines the basis for those injunctions elsewhere. So the Little Sisters may really have an interest in this litigation, even though there are injunctions in Colorado and Texas and so forth that are nationwide, or at least cover nationwide classes that seem to protect them even if they lose here.
Yeah, this was the justices did end up discussing this issue a little bit in the context of discussing nationwide injunctions, and part of the point that was being made there is, whatever oddness there is about our standing is actually a feature of maybe the oddness of the nationwide injunction in the first instance. And it is weird to say, you're protected by this nationwide injunction, so maybe you don't have standing, or by the time you're in the Supreme Court, it's very clear that what the Supreme Court says is going to affect your nationwide injunction and whether you get to keep it.
Yeah, maybe you know the answer to this though, Eric, and I don't really, but you may not be in the weeds enough to know. But Judge Reed O'Connor in Texas issued an injunction with respect to the contraception mandate in favor of Little Sisters, and a nationwide class. So it wasn't a nationwide injunction in the sense, he wasn't saying like these rules can't be applied anywhere. He's saying like, this is a big class.
Yeah.
And it has members nationwide. And so I'm ruling in favor of this class and all its members. Does that raise the same kind of problems?
No, in fact, that is, I think, the classic use of the old school, even class action, the one that predated Rule 23, where you had people who want common injunctive relief against the government. If you are certified, now, I mean, I don't know whether that class certification was correct or would hold up, but if you assume that it does, that's not the same as the problematic kind of nationwide injunction we have now, though note that it has the exact same effect.
Right.
If you define the class that way,
right,
then it should have the exact same effect. But
right.
But one issue is that a class defined that way also should prevent other people from litigating this case separately in
right.
other places.
Right.
So we've generally tended not to view the. I'll just say this, because the tradition of the government now is to comply with these injunctions, basically on a nationwide basis, even if they're not issued as nationwide injunctions, where they don't want to violate the terms of a court order in New Hampshire just because the court order was issued in Massachusetts. We really didn't face this problem. It's only because we have it's a more contentious environment now.
Right.
Where this question is now coming up.
Right.
And the courts will have to think about how they think Rule 23b2, which is the injunction class, interact with their nationwide injunction. I say looming Supreme Court frustration with nationwide injunctions.
So you were a good person to ask about that, but I think we should wrap up, right? I think we're kind of time.
We're way over time. Anyway, thank you for doing this, Nelson. Thanks to everybody. It's been a lot of fun, and maybe the Supreme Court will continue releasing same-day audio even when the crisis is over to permit stuff like this. I think it does probably drive public engagement, even if there's the occasional toilet flush on the audio line.
Thanks, Eric. All right. Thanks, everyone.